Hello friends, in the series on the income tax cases, today we will discuss a very important issue regarding the jurisdiction of the assessing officer in passing the assessment order. It has been seen that when the two assessing officers are under the same principal commissioner of income tax, the cases are transferred from one assessing officer to another assessing officer. It is a tried law that whenever the case of an assessee is transferred from one city to another, then the order under section 127 subsection 2 is to be passed and the assessee is to be given an opportunity of being heard because his case is transferred from one place to another. But the question arises that when the case is to be transferred within the same city and when both the assessing officers from where the case is transferred and to whom the case is transferred are in the same city and under the jurisdiction of the same principal commissioner of income tax, so whether in that case the transfer order under section 127 is required or not, or if that order is not passed, whether the assessment in those cases is valid. This issue has been taken up by Kolkata ITAT B bench in a very interesting judgment, Nisha Baheti versus Assistant Commissioner of Income Tax. This case is reported in 124 ITR Tribunal, short notes 33, and the date of the judgment is 2nd May 2025. The assessment year is assessment year 15-16, and in the present case a notice under section 143 subsection 2 was issued to the assessee by Kolkata Circle 31. After issuing this notice, the revenue realized that the jurisdiction of the assessee is with the Circle 11-2, so his case file was transferred from Circle 31 to Circle 11-2 without the order under section 127. The assessee was not aware of this requirement at that time, and the assessment was completed by the Circle 11-2, who was the jurisdictional assessing officer of the assessee, and he made the addition on the basis that the sale and purchase transactions done by the assessee and long-term capital gain claimed as exempt under section 10 subsection 38 is bogus. The assessee filed the appeal before the CIT appeal, and the CIT appeal was also of the considered view that in the present case the assessee has failed to prove the genuineness of the transactions for the purchase and sale of shares, so he upheld the order of the assessing officer. The matter was before the tribunal. The assessee first time raised the ground that the notice under section 143 subsection 2 has not been issued by the officer who has passed the assessment order. In the present case, there was no denying the fact that the notice under section 143 subsection 2 has been passed by Circle 31. But Circle 31 has not passed the assessment order. Circle 31 has transferred the file to the Circle 11-2 who has passed the assessment order, and after transferring the file, the Circle 11-2 didn't issue the notice under section 143 subsection 2. So it was the submission of the assessee that without issuing the notice under section 143 subsection 2, the officer who has passed the assessment order, that assessment order is null and void. When the tribunal heard the matter, the tribunal was concurring the view of the assessee and said that in the present case, the assessment is null and void from ab initio. The revenue came with the contention that it was the duty of the assessee under section 124 subsection 3 to raise the jurisdictional point within 30 days as per requirement of section 124 subsection 3. But for that, the Kolkata ITAT said that this issue has been taken care of by the Honorable Apex Court in the case of Deputy Commissioner of Income Tax Assumption versus Karinga Institute of Industrial Technology, which is a 2023 judgment and which is reported in 151 ITR 151 Taxman at page number 434. The Kolkata ITAT also relied some other judgments like Kusum Goyal versus Income Tax Officer, which is a 2010 judgment, which is given by the Honorable Calcutta High Court. Another judgment, Kashiram Agarwal versus Union of India, which is also a Supreme Court judgment. SL Singhania and others versus Assistant Commissioner of Income Tax, which is a Delhi High Court judgment. And another judgment of Calcutta High Court, that is Subhash Chandra Bani Ramka versus Assistant Commissioner of Income Tax, which is a 2010 judgment. Friends, this case is very important because in a number of the cases it has been seen that the department is following this practice very casually. Then the notice is being issued by one assessing officer, then the file is transferred to the other assessing officer, and when we file the RTI, we came to know that the department do not have any section 127 order. So in all those cases, the transfer of the file from one assessing officer to the another assessing officer without the order under section 127 is null and void as per this judgment. At the end of this video, once again I am repeating the name of the case. The name of the case is Nisha Baheti versus Assistant Commissioner of Income Tax, and this case is reported in 124 ITR Tribunal Short Notes 33, and the date of the judgment is 2nd May 2025. Thank you, friends.